Welcome back, everybody, to our studies in public law. We're continuing talking about the concept of judicial review, in this lesson, specifically the grounds for judicial review, and even more specifically, the idea of proportionality in relation to judicial review. Now, the concept of proportionality is going to be the topic of this next few lessons. But as just a basic recap, what we did in the previous videos was look at the concept of irrationality judgment in judicial review cases. Specifically, we delineated, I apologize, between the concept of irrationality, procedural impropriety, and the ideas of things related to Wensbury unreasonableness on the one hand, and then we applied these specific considerations to applications involving human rights on the other hand, which is of course a separate and distinct conversation that we had. Now, this lesson is going to start talking about the concept of proportionality. Noting in the previous lesson, by the way, as a basic understanding, is that the traditional test of Wensbury unreasonableness does not necessarily provide adequate protection for cases concerning human rights. This lesson, as I've said, is going to talk about the concept of proportionality. Now, the concept of proportionality is going to relate to a number of different principles here. This is the final major element relating to grounds for judicial review. A lot of different issues are going to be discussed. Things like procedural impropriety, things like legitimate expectations and natural justice will also be examined before we then park our understanding in our conversations about the grounds for judicial review and start talking about some of the applications of administrative law, specifically examining the idea of police powers. So let's begin then. Proportionality. Fundamentally, a judicial review claim that involves human rights will involve allegations of an individual's right being limited in a particular context, or potentially it could be a plurality of rights. Multiple rights may be violated or allegedly be violated. The state, in limiting the rights, then have to show, by way of a proportionality test, some kind of justification for the particular government policy or particular local action in limiting that right. So they must perform a proportionality assessment in order to ensure that the decision to impose some kind of limitation on rights does not go beyond the intended effect of the public decision. So fundamentally, if I was a local authority, or I was the government, or I was a government department that had a certain amount of administrative function, and I was implementing a policy, and maybe I have good grounds and I have good reasonable reasons for implementing this policy. I might think that it aligns more with the mandate of the people, or maybe on national security grounds, whatever. And in doing so, I know that this might produce a limitation or involve a potential limitation on certain human rights in particular contexts. In order for this to be valid, or the first thing I need to do is make sure that the intended effect of this policy does not overly and disproportionately limit the human rights of an individual in that particular context. So when looking at proportionality in decisions, there must be a reasonable relationship between the objective that is sought to be achieved by that policy and the means by which they are going to go about implementing that policy. So when the idea of proportionality is therefore discussed, and when a decision is actually then challenged, those who bring a judicial review claim are not making an argument that the end goal or the objective is necessarily illegal or irrational, which is, of course, the previously examined two claims for judicial review, two grounds for judicial review. Rather, you're making an argument that in the course of conduct, the method by which the achievement of that goal has been achieved is unjustified. It's not proportional to the end goal itself, and may disproportionately impact the human rights and individual rights of people involved in that decision. Let's begin then by looking at quite a major case in determining proportionality, which is the case of Bank Millat versus Her Majesty's Treasury, the second version from 2013. What this case does is confirm certain previous cases that I'm not going to examine here because this is really just the culmination in those cases. And it approved that the test for proportionality will have 4 distinct features, sometimes known as limbs, the limbs of the proportionality test. There will be 4 major limbs of this test. These are not perfect, nor do they have definitive conclusions in regarding the interpretation of this test. But this was essentially, in terms of examining the case itself, it was a case which involved the imposition of financial restrictions on Bank Millat by Her Majesty's Treasury. So Her Majesty's Treasury obviously representing a public body, a public authority. They did so on the grounds that the bank itself was involved in the financing of the Iranian nuclear program, which of course the government had a policy of being strongly opposed to, and as they should. Now, they argued that the bank themselves, in fact, argued that the banning of or the imposition of financial restrictions on the bank for this reason was actually in contravention of their Protocol 1 rights under the European Convention on Human Rights. Article 1 of Protocol 1 concerns the right to property as well as the right to the enjoyment of business. So essentially, you are limiting our ability to do business and our right to property under the ECHR by limiting and placing financial restrictions on us. The question for the Supreme Court, therefore, was whether or not this decision to limit the finances was actually proportional to the policy to be achieved. The policy to be achieved was, of course, to maintain that there is financial restrictions on those who finance Iranian terrorism or finance Iranian nuclear programs. And so the question had to be asked for the Supreme Court. The goal of the Treasury, of course, is to hinder the development of the Iranian nuclear program. This is a goal which was enshrined in statute, and it was a statutory goal, so you ought to bear in mind, of course, the fact that parliamentary sovereignty exists here. And so the result here is asking the question of whether or not those financial restrictions that were imposed, whether or not those financial restrictions, in fact, were proportionate. The Supreme Court held that they were not proportionate, and as a result of which the decision was unlawful. And so, in making a determination of proportionality, the Supreme Court, specifically headed, the judgment was headed by Lord Sumption, came up with a number of tests for determining proportionality. This was the 4-stage test. And this test involved the first question, which is, given a limitation of a right, was the objective of the policy sufficiently important? So you're asking the question of importance in relation to this policy. That's the first point that you have to ask. The next was the measure for implementation rationally connected to this objective? So it seems to make sense that it was rationally connected if the policy and the goal and the end goal is to hinder the development of the Iranian nuclear program. Then, if you believe that a bank is financing Iranian nuclear technology, then imposing financial restrictions on them was, of course, going to be rationally connected to that objective. The third point, which is probably the most controversial point, is, quote, could there have been an alternative measure imposed which was less intrusive? This is one of the major questions that has to be asked, okay? It is not necessarily dismissing the goal of the policy or even necessarily the validity of going after the bank in question, but more so attacking the validity of the process, attacking the validity of the ways in which essentially the government or the Treasury, in fact, went about trying to impose these restrictions. Could they have done so in a different way, which was less intrusive, but still maintained and achieved the same goal? And then finally, is there a fair balance which has been struck between the claimant's rights and the public interest? So remember that there is a balance that has to be made between the public interest and the claimant's rights, such that you can restrict the claimant's rights in relation to the achievement of a public interest. And there has to be a balance there. It has to be proportionate. It can't be disproportionate in that particular goal, in the aim for that. Fundamentally, when it comes to debating these different points, the third consideration is arguably the most heavily debated one, the one that will attract the most debate for most circumstances, and you can understand why, given the nature of the third consideration. Because what Sumption argues in applying this third consideration is that a measure would be disproportionate if any more limited measure could be imposed which achieves the same goal. So let's say if you had a choice of two measures, both measures achieve the same goal, and one is more limited, less restrictive, and easier to achieve than the other one, then you would argue that you would go for the less intrusive goal to achieve proportionality. And any other goal would be disproportionate. That's what Sumption argues. Lord Reid, on the other hand, concludes that the third consideration refers to the reasonableness of the measure to be imposed. So to what extent is the measure imposed reasonable given the circumstances? Both of which are obviously potentially valid considerations that can be made. But fundamentally, what this does is it reflects the ways in which we can understand how proportionality is achieved in these various circumstances and in these different cases. Welcome back, everybody, to our studies in public law. In this lesson, what we're going to do is talk about the idea of procedural impropriety. Now, this is also in consideration of the grounds for judicial review. We focused on this idea of irrationality. We talked about the concept of illegality, Wensbury reasonableness. We talked a little bit about proportionality. This, like I said, is going to begin talking about the concept of procedural impropriety. This is considered to be the third ground for judicial review, which was cited by Lord Diplock, if you remember back to the case that we examined all the way at the beginning of this series of lessons on the concept of judicial review. So, as an introduction, the concept of procedural impropriety. What does the concept of procedural impropriety actually refer to? Well, essentially, it refers to circumstances and situations in which the executive body, the body or the local government or whatever that is under the particular scrutiny that we're applying judicial review to, has acted in a way which fails to observe various different procedural rules. So they're not necessarily acting in a way that is illegal. They're not acting in a way that is irrational necessarily or not proportional. But they are failing to observe some of the basic procedural rules that exist when it comes to the implementation of various different legislative considerations, the application of law, whatever kinds of policies that they're looking to implement. We can take these procedural rules that we're thinking about and sort of condense them into two basic principles. Because there are lots of different procedural rules, we're not referring to every single different type of procedural rule in every single different circumstance. The procedural rules that we are referring to generally fall into one of two categories. Failure to observe the procedural rules which are applied in statute. So obviously, a lot of local government or executive bodies have their authority derived from statute, and a lot of statute will apply or ensure that there is the application of various different procedural rules, and these would be enshrined within the statute itself. Alternatively, we can think about the failure to observe procedural rules which are laid down by the principle of natural justice. The principle of natural justice is a little bit more vague, a little bit more holistic, but it does come attached with it a number of important elements and important principles that we will get to in future lessons' time. But generally speaking, we can sort of distill, if you will, the idea of procedural rules into either rules relating to statute or rules relating to natural justice. So, in terms of looking at statute and failure to observe statutory rules, it can be said that a public body has acted ultra vires. It has acted beyond its authority, and therefore there is a legitimate ground and a legitimate case of judicial review in circumstances in which they have failed to comply with the prerequisite procedural requirements which are then laid down by a particular piece of legislation. So a legislation, like I said, will give the authority of an executive body to do and perform certain actions, to pass certain rules and regulations in certain circumstances. But a lot of these pieces of legislation will also have attached to it various different ways in which procedures ought to be followed in order to ensure that the law is actually being applied in a correct way. And so, given an example here, we can think about the case of the Agricultural, Horticultural and Forestry Industry Training Board versus Aylesbury Mushrooms. This is a case from 1972. If you were to write this case or to cite this case in an exam, and you were handwriting an exam, you would probably be fine by just saying Aylesbury Mushrooms, 1972. When there are very, very, very long cases that either will eat up your word count or it will take too long to write down in an exam, just cite the respondents to these cases, or the defendants in these cases, because then people will understand what you're referring to, and obviously cite the date as well. This case concerned the establishment of an industrial training board. This was under the executive branch, established under the executive branch by and under the remit of the Industrial Training Act of 1964. So the Industrial Training Act of 1964 is the parliamentary legislation that was passed that gives the executive branch certain authorities for the establishment of industrial trainings boards. And there are obviously different ways in which this ought to be done. There were procedures that had to be followed. When it comes to enabling legislation such as this, the creation of such a board would require consultation with the appropriate authorities on the part of the minister in question. So the minister that is authorized to be creating these training boards, so potentially the agriculture minister or potentially some other kind of minister of state, they would have to consult the appropriate authorities, the appropriate experts essentially, before creating such a board. This legislation was no different. In Section 1, Subsection 4, there was the requirement under the Industrial Trainings Act for the mandatory consultation with the relevant authorities. This is representative of the procedure that we're talking about, the procedural element of the legislation that we're referring to, such that if you do not act within this procedural element, you could be brought up on charges of procedural impropriety, essentially. The minister had therefore consulted with the National Farmers Union, but was not the subsidiary of the NFU, the Mushroom Growers Association. So we have a number of different problems here. So the question here is essentially: did the minister act ultra vires in creating the trainings board by only consulting the National Farmers Union and not consulting the Mushroom Growers Association, which was a subsidiary? Now, like we said here, the question of consultation was held to be mandatory. So the question of who should be consulted, however, was seen to be something which was dependent on the subjective belief of the minister. So what we have here is an example of the discretion that can be given to ministers in certain circumstances when it comes to their application of procedure. All that really is required is the mandatory consultation with the relevant authorities. Who actually counts as a relevant authority is a question that really lays a little bit to the minister, but of course, obviously can be considered within the context of the legislation as well by the courts, because if the minister consulted a completely different union or a completely different association, then of course this would represent something of a failure to consult with the, quote, relevant authorities. So the question of, like I said, the question of consultation was held to be mandatory, but the question of who should be consulted was seen as something which was therefore dependent on the subjective belief of the minister. And you also had to take into consideration what was meant by the word consultation. To what extent was a meeting, or what extent was a back and forth discussion a consultation? What counted as a consultation? So essentially, who was to be consulted in this circumstance, and what did it mean to consult in this circumstance? Well, The courts held that consultation meant a communication of genuine invitation with the view that there would be the granting of advice. So a consultation wouldn't be, for example, the minister meeting the National Farmers Union and telling them what is going to happen. That doesn't seriously represent something of a consultation, because it wasn't a communication of genuine invitation, and there wasn't the view that there would be the granting of advice from the Farmers Union. It was therefore held on account of the nature of the meeting that was had and the people who were met with in creating these training boards, that there had actually been no consultation. And so as a result of which, the minister had acted procedurally ultra vires, and would have been found on this ground to have acted ultra vires on the basis of procedural impropriety. So in the previous lesson, we started to talk about the concept of procedural impropriety as one of the other grounds for judicial review. We noted that you can generally justify procedural impropriety as encompassing one of two major categories, i.e. failure to follow procedure which is laid down in statute, which is what we looked at in the previous lesson. And then the second point is failure to follow procedure that is laid down by the basic principles of natural justice. This lesson is going to think about those basic principles of natural justice. We'll talk about what natural justice is, some of the basic elements of natural justice, as well as a couple of cases that illustrate the point of natural justice as well in relation to judicial review. So, we'll examine the two main maxims of natural justice by which procedural fairness, or the converse obviously being procedural impropriety, has to adhere to. And like I said, we'll examine some key cases which illustrate these principles in more detail. So, simply put, the two main principles of natural justice are the following. I'm not going to try and read the Latin phraseology. Thankfully, we have translations to them. The first suggests that we should hear both sides of a case, and the second is that no person should be a judge in their own case. These are the basic principles of natural justice. So everybody has a right to be heard and a right to have their case be presented and a response to be presented. And then secondly, nobody should be a judge in their own case. So that a case ought to be judged by an independent body, an independent analysis. So essentially, we can distill these two principles of natural justice down to, firstly, there ought to be a fair hearing, and secondly, there ought not to be any bias. There should be no bias within any particular case. And essentially, these are very wide principles. The scope of these principles are incredibly expansive, and given that, and given that basic idea, it makes sense to suggest that the courts have had to grapple with these principles over the years and have spent some time dealing with and discussing and coming to grips with these basic principles and these basic conclusions. And really what I'm going to do for the rest of this lesson is just illustrate how the principles of natural justice have been laid down in various cases. The cases that I look at aren't by any means an exhaustive list of cases that we can think about. There are various different cases that we can look at. I've just found some of the most popular cases, some of the ones that are most cited in and around the textbooks, and are generally seen to be the most popular cases on this topic. And I'm going to begin here with the case of Ridge and Baldwin from 1964. This was a case in which a committee was attempting to remove a chief constable from a borough police force. So we have a committee that was trying to get rid of a chief constable from a police force. The officer had been arrested and had been charged with a conspiracy to obstruct the course of justice. So that was their sort of rationale for trying to remove them. They were arrested and charged with an offence, which of course doesn't look good if you are a chief constable in a police force. He would be acquitted of those charges, but the committee still attempted and were successful in dismissing him through the exercise of their authority under Section 1914 of the Municipal Corporations Act of 1882. Now, they did so without giving the constable any opportunity to present their case. So the question here is of natural justice, of the basic principle of the right to be heard. When this was challenged through judicial review on the basis of natural justice and procedural impropriety, it was held that, by the Court of Appeal, it was held that such principles did not apply in situations in which there were administrative situations, the situations were administrative in nature. The House of Lords, however, would allow the appeal, noting that the Chief Constable ought to have an adequate information of the charges, as well as an opportunity to be heard in response to those charges. There's a bit of a back and forth here. Even though they did so, they did the acquitting or the dismissing, should I say, of the police officer under the provisions of statute, the Municipal Corporations Act. They didn't follow some of the basic principles of natural justice in doing so. And so as a result of which, the House of Lords held that the Chief Constable ought to have both adequate information of the charges as well as an opportunity to be heard in the case. It was argued that just because there was no clear definition of natural justice, it does not mean that one cannot conclude that it does not exist, or can conclude that it does not exist. So basically, one of the arguments that was had here and that was presented is that because natural justice is a vague principle, it doesn't really have any clear and definite descriptions, then it cannot be said to have applied. Obviously, this doesn't make any sense, as you would understand, and so the result here is that fundamentally, just because natural justice is a principle that does not have a clear definition, it does not mean that you cannot conclude that natural justice does not exist. This case also illustrates what some of the principles of natural justice actually are. And according to Lord Hodgson, there are three such principles of natural justice: a right to be heard, a right to notice of the charges, and a right to be heard in answer of those charges. So the first one is obviously the basic principle that you have a right to present a case in response to the charges that have been presented against you. You also have a right to notice of the charge. You also have a right to adequate notice of the charge. And you also have a right to be heard in answer of the charges that have been presented against you. A more recent case is from 2014. This is a case of A versus the BBC, and this goes all the way up to the Supreme Court. Now, what this case is illustrative of is that where there is actually a strict application of the constitutional principles of natural justice and the rule of law, in the circumstances in which there may be the creation of injustice, significant injustice, the court will have the ability to depart from such principles. So basically what it's saying here is, in certain circumstances, a strict application of natural justice might in fact bring about significant injustice in response, and in those circumstances the court will have the ability to depart from the principles. The principle that was at stake here was the basic principle of open justice, the idea of cases being public and cases having people being seen to have justice be done onto them and have justice applied to others on their behalf in an open and a visible manner for the entire public. We don't want this idea of there being secret trials that take place without anybody knowing, because obviously that wouldn't be particularly very democratic. And so what we have here is a case in which we have a convicted child sex offender. This is an individual who goes by the name of A. Obviously, their name is not published. They were a convicted child sex offender who were actually at risk of being deported back to his country of origin. The deportation order was challenged on the basis of Article 2 and Article 3 under the European Convention on Human Rights. There are Article 2 rights and there are Article 3 rights. Article 2 pertains to the right to life. Article 3 is the prohibition of cruel and inhuman treatment or punishment. Sorry, torture and inhuman treatment and punishment, essentially. These, of course, were justified on the basis that if this convicted child sex offender was to be deported back to his country of origin, that deportation order would likely have either caused death or torture or ill treatment or punishment to this individual on the basis of the general understanding of that country and knowledge of the country in which they were being deported back to. So the deportation order was challenged on the basis of protecting their Article 2 and Article 3 rights. He would seek judicial review under the upper tribunal's decision to deport him, at which point his name and address would be deleted for the purposes of anonymity. One of the really key and important things that needs to be noted here is that when we deal with cases involving child sex offenders, or where we're dealing with cases involving people who commit child abuse, murder of children, all these different kinds of things, there are human rights considerations to be had when it comes to publishing their name and their address, obviously because of the fact that these are particularly heinous crimes that are committed against children, and the United Kingdom has quite a significant, often people in the United Kingdom have a significant response to people who are child sex offenders, and there is quite a lot of violent backlash against them. And there are numerous occasions in which child sex offenders will have their name anonymized in order to protect their identity, in order to protect their rights. Either their right to life under the Human Rights Act, if we're talking in a domestic setting, or if we're talking about this deportation order, their Article 2 right to life under the ECHR. Basically the same principles. In addition to having their name and address deleted for the purposes of anonymity, the courts also sought to get an order under Section 11 of the Contempt of Court Act, which essentially meant that no media publication would be able to publish his name and address. This was, of course, something that would be challenged by the BBC. The BBC challenged this order on the ground that it broke the principles of natural justice and the idea of open justice, that it would go against the basic principle of open justice to not allow the publication of his name, the individual who was a convicted child sex offender. And so as a result, they challenged this order. And so we see here an imbalance, or we see here a clash of principles. On the one hand, you have the basic principle of open justice, which would have led to his name and address being published, or at least his name. But then you have the challenge of that on the basis of his right to life and his right to, and his freedom from, should I say, torture and ill treatment. The Supreme Court sided with the order, at least for the insurance that there would not be the publication of his name. They held that there would be the insurance of the anonymity of A. And they justified this on the basis of human rights. And they said that, quote, where a conflict is between the media's rights under Article 10 and an unqualified right of some other party, such as the rights guaranteed by Articles 2, 3, and 6.1, there can be no derogation from the latter. So they noted here that there is obviously a clear indication of something of a hierarchy of rights, at least within the ECHR. This is something that has been known to be the case from the earliest days of convention jurisprudence. But it also noted here that where there is a conflict here between Article 10 and Article 2, 3, and 6.1, there cannot be a derogation from the latter in order to protect the rights of the former. In addition to this, where there is significant injustice that is going to be had from the application of basic principles of natural justice, we can derogate from basic principles of natural justice to ensure that an unjust outcome does not come into fruition. Welcome back to our studies in public law. This is in fact our final lesson on the grounds for judicial review. We've done 12 in total. And we're going to talk about this idea of legitimate expectations, which is just a little final point to wrap up the rest of this topic. Now, fundamentally, we're going to explore this last topic here on legitimate expectations, and then we're going to move away from judicial review to looking at police powers. And then we will finish off with some members-only content looking at public order and terrorism legislation and right to assembly and all these different kinds of things. So, This lesson, we're going to look at the concept of legitimate expectations. We shall explore the language of legitimate expectations, where it was first introduced into the law, and some of the implications of it therein. Fundamentally, when we think about legitimate expectations, we have to first ask the question, what are legitimate expectations, and how does this apply to the grounds for judicial review? Well, a legitimate expectation is simply something that is said to be lesser than a right, not quite as strong as a right, but still protected under the ordinary rules of natural justice. So, think of legitimate expectations firstly as a subset of the basic principles of natural justice, for a start. So we're still talking about procedural impropriety, we're still talking about that as a ground for judicial review, we're still talking about natural justice being legitimized under that particular basis, but we're thinking about the idea of legitimate expectations here. The term was first coined by Lord Denning in the case of Schmidt versus the Home Office from 1969. Specifically in this case, we have a group of students who are residing in the United Kingdom, and they are residing at the Hubbard College of Scientology. So, for those of you who don't know what Scientology is, there's a South Park episode that seems to summarize Scientology actually quite accurately. And fundamentally, the Home Secretary wanted to have their stay extension rejected. So they were residing in the United Kingdom. They had their stay extension that essentially they wanted to have an extension of their stay in the United Kingdom, and the Home Secretary wanted to have that get that rejected and then get them deported, essentially. They applied for judicial review on the grounds that what this rejection did was represent a violation of the basic principle of natural justice, namely the basic principle that every single person has a right to be given a fair hearing, and so they ought to have a fair hearing before they have their stay extension rejected. The Court of Appeal rejected this claim. They rejected this judicial review argument, arguing that the applicants did not have a right to stay, nor did they have a legitimate expectation that this stay would be extended. So, like we said, remember, not exactly a right, but a legitimate expectation. Read that using the sort of ordinary meaning of the words and the language that you would come across when you are just reading ordinary English. They said, quote, "If the foreign alien's permit is revoked before the time limit expires, he ought, I think, to be given an opportunity of making representations, for he would have a legitimate expectation of being allowed to stay for a permitted time." So fundamentally, there was not a legitimate expectation that they would have their stay extended. And so we can then go from this to another case, the case here of Pamponet versus the Attorney General of Trinidad and Tobago, and we can see how the application of this principle extends. This case was a case involving the Privy Council, of course. We're talking about parts of the Commonwealth, Trinidad and Tobago. And it was made clear by the Privy Council in this case that a legitimate expectation must be based on a promise, representation, or an undertaking. So the previous case that we just looked at coins the term legitimate expectation, and we see this as something that is not quite a right, but maybe something a little bit lesser than a right. But it doesn't give us much about what actually is a legitimate expectation, where a legitimate expectation should be based, how it should be formulated, and what foundations can we really understand to be the basis for legitimate expectation. This case gives us a little bit more clarity in relation to this. It's based on a promise, representation, or an undertaking. In addition, there must be a certain amount of clarity. It must be unambiguous, and it must be devoid of relevant qualification. These are really where we see the existence of legitimate expectations. The case itself concerned an association of taxi operators who all had their own taxi stands. They were given the opportunity to move their taxi stands into a transit centre, which was operated by a separate company. This was operated by their competitor. The point here, essentially, was that they were supposed to have the ability to own and manage their own stands, but would be doing so under the ownership of this company, sort of under the umbrella of this larger company. However, What then happened was the company then introduced a fee of $1 for each exit journey, which then, of course, would cost the taxi operators every time they left this taxi area, this separate separate transit center. They applied for judicial review on the grounds that they had legitimate expectation that they could manage their property without a fee. So notice here, this isn't a right. They don't have a right to manage the property without a fee. They had a legitimate expectation. It was expected on the basis of the agreement that was made and on the basis of the nature of the agreement that was eventually formulated that there wouldn't be a fee in the operation of their business. Then subsequently a fee then gets introduced, which is then of course in contrary to this legitimate expectation. It was held by the Privy Council that this was indeed a legitimate expectation and that this was indeed enforceable. And so they did have a good claim in judicial review. In terms of representations, it was held that it must be clear, unambiguous, and devoid of qualifications, as we noted, and that it must be based in either a promise, representation, or an undertaking. So if they were promised, clearly promised, that they would be able to operate their taxi journey, their taxi business, without a fee inside this transit center, then you have a clear, unambiguous promise which is devoid of relevant qualifications. This then basically forms the basis for the existence of a legitimate expectation. Finally, then, let's look at this case here, a very recent case from 2019. This is an application of judicial review from Northern Ireland, and it was a case which involved the murder of a man by in Northern Ireland, shall I say, by loyalist terrorists. I'm not going to get into the back and forths of the various different contexts in which terrorism and radicalism and political radicalism took place in Northern Ireland. Go and read the Troubles if you want to have a better understanding of the history. But fundamentally, we have a loyalist terrorist in Northern Ireland that had murdered an individual. The widow of the man argued that she, in fact, had a legitimate expectation to a public inquiry into the death of her husband. The reason for this was relating to a report which was done by a judge, which indicated that the loyalists may have been in collusion with various different security services, of course, which worked for the British government. So there was this potential conspiracy, if you will, of the British government having something to do with or having some sort of collusion with, by extension of their security services, this loyalist terrorist group, which then went on to murder this woman's husband. She thought, I have a legitimate expectation to a public inquiry, given the fact that there was some shady things going on, potentially shady things going on, between these loyalists and the security services working for the British government. It was held that even though it was sufficiently clear and unambiguous, it was considered that there was an overriding interest on the part of the government, which could serve to frustrate the legitimate expectation. This is quite interesting, because essentially what the Supreme Court does is hold that there is a sufficient clarity, it is sufficiently unambiguous, and so that upon an ordinary reading, you would be inclined to conclude that there was a legitimate expectation. But they said that there was still, however, an overriding interest. This was an overriding interest on the part of the British government. They held that, quote, where political issues overtake a promise or undertaking given by government, and where contemporary considerations impel a different course, provided a bona fide decision is taken on genuine policy grounds not to adhere to the original undertaking, it will be difficult for a person who holds a legitimate expectation to enforce compliance with it. So this is essentially a case which caveats the existence of legitimate expectations. Not only do you have to prove the existence of a legitimate expectation first in order to try and get a successful judicial review claim, but you also, secondly, have to have a legitimate expectation which cannot be overridden by political issues and by genuine bona fide decisions that are taken on policy grounds which would not adhere to original undertakings. At which point courts would often sympathise and often side more with the government than with you, essentially. Saying here, quote, "It will be difficult for a person who holds a legitimate expectation to enforce compliance with it."